There was a gray rubber joystick cap on the evidence table. It sat in a clear plastic bag with a white sticker across the top. One side of it had been worn smooth by a child's thumb during a clinic trial. That little piece of rubber is why I am talking now. It came from a pediatric power chair Elena Ruiz used for 23 minutes on May 29, 2024, in a rehab gym in Santa Ana. 23 minutes. That was enough time for her therapist to see what she needed, enough time for her mother to cry in the hallway, and enough time for a health plan executive to decide the chair cost too much. Before I go further, I need you to subscribe. Not as a formality, because there is one piece of evidence in this case, something small, something easy to miss, that changed the whole direction of my ruling. I want to make sure you are here when I get to it. Subscribe now, then I will keep going. When Elena Ruiz first came into my courtroom, she was 10 years old and wearing a yellow star clip on the left side of her hair. She sat in a loaner chair that squeaked once every full turn of the right wheel. Before anyone called the case, she leaned toward her mother and said the dinosaur on her coloring book was not a T-Rex, it was an Allosaurus. I wrote that down in the margin of my notes because it told me who she still was. She looked straight at whoever was speaking to her, even when the words were words no child should have to hear that often. Coverage, review, medical necessity, denial. She never asked for pity. The first full sentence I heard from her in court was, "I do not want people pushing me all day." She said it plainly. I have not forgotten it. Her mother, Marisol Ruiz, came in every day with a canvas grocery bag full of folders, blue for medical records, green for school notes, yellow for receipts. She was not a lawyer. By the second day, she knew that file as well as anyone in the room. I saw her square the edges of the papers again and again while witnesses spoke, as if keeping the stack neat might keep the story from falling apart. Martin Voss came in with 2 lawyers, a leather folio under one arm, and a silver watch that flashed when he moved his hand. He was 48 years old, Senior Vice President of Utilization Management for LatticeCare Health Plan, and he carried himself like a man used to being heard before he finished speaking. He did not look at Elena Ruiz until late on the second day. I watched him when he thought no one important was watching. He sat very still when his lawyers spoke. He only moved when one of his own people was on the stand. Then he would press his thumb against his wedding band and look at the far wall above counsel table. He had the habit of a man managing himself. By the time he sat at that table, I already knew the outline of what happened. I knew it from records, call logs, emails, declarations, and timestamps buried in a claim system. I was not in the Ruiz apartment when it began, but after hearing it so many times, with so many details lining up, it felt less like a report and more like memory. It started Friday, June 14, 2024, at 9:12 a.m. in apartment 3B on West Pine Street in Santa Ana. Marisol Ruiz was on the phone with LatticeCare. Elena was at the kitchen table doing summer math work. Before the plan was a request for a pediatric power wheelchair with tilt, pressure relief, lateral trunk supports, and a custom joystick mount. Dr. Priya Rahman had prescribed it on June 3rd. The therapist's seating evaluation had gone in that same day. School support notes followed on June 5th. At 9:12 a.m., a claims representative read from a screen and said the request was denied because manual propulsion was adequate in the home and school setting. That phrase showed up everywhere in the file. It sounded tidy. It sounded settled. The trouble was that Elena Ruiz had a T8 spinal cord injury, shoulder strain from overuse, and weak grip on her left side. Manual propulsion was not adequate. Every person who had actually treated her said so. 2 days before that call, on June 12th at 8:03 a.m., Martin Voss joined a video meeting from LatticeCare's office in Irvine. A former analyst later testified about that meeting, and I saw part of it in evidence. When the discussion turned to pediatric mobility requests near quarter close, he said, "We are not buying a Cadillac because a family wants comfort." He said it. No one corrected him. I am going to tell you something that did not come out until the 3rd day of testimony. Something that, when I heard it, I had to ask the witness to repeat. If you are not subscribed yet, do it now, because that moment is coming, and I do not want you to miss it. The case did not start as a criminal case. Most people would not know that. The first papers on my desk were filed on June 24, 2024, as an emergency petition for medical access and injunctive relief. Elena had already missed summer school orientation because the loaner chair could not be pushed safely over the broken pavement between the bus stop and the side entrance of her school. Her lawyers asked for one thing first: get the chair delivered. I signed a temporary access order 48 hours later. At that stage, the file already showed clear medical need and risk from delay. What changed the case was what happened next. Lattice Care did not simply comply and save its arguments for later. It produced records late, delayed vendor contact, and told the court that the denial had been based on a completed physician review. That drew the state attorney general into the case. By August, the matter had widened into fraud, false records, and contempt. There is a detail people outside the system often do not know. A denial letter is not just the final page. Behind that letter is a trail: who opened the file, when they opened it, whether the physician review came before the draft or after it, whether the language existed before the doctor ever touched the case. In this matter, that hidden trail mattered more than the clean words on the denial itself. I remember the entrances on the first trial morning because I saw them from the bench. Marisol Ruiz came in first, pushing Elena in the same squeaking loaner chair. Their lawyer, Cynthia Bell, carried a banker's box with red tabs sticking out across the top. Elena had a blue blanket over her legs, though the day was warm. She kept one hand on the chair rail as if she did not trust it. Martin Voss entered 7 minutes later through the side door with Alan Mercer and Diane Cho. Mercer was still buttoning his jacket as he walked. Voss set down his folio, lined up 2 pens beside a yellow pad, took out a bottle of sparkling water, and turned the label away from the gallery. He looked at the witness stand. He looked at me. He did not look at the Ruiz family. The first wave of evidence was not loud. It did not need to be. It laid down the ground. Dr. Priya Raman testified that Elena's spinal cord injury came from a car crash on January 22, 2023, and that by spring 2024, her shoulders were already showing overuse from trying to self-propel equipment not built for her body. Dana Shu, the pediatric physical therapist, walked the court through the seating evaluation line by line. Measurements, pelvic support, tilt needs, pressure points. Dana Hisu brought the joystick cap, the same little gray piece in the plastic bag. She said the demo chair from the rehab gym had been cleaned and returned, but Elena had asked if she could keep that removable cap after the trial session. Dana said Elena rolled the demo chair 12 feet across the gym floor, made a slow left turn, and then said, "I can get to the bathroom by myself in this one." Dana said it the way Elena had said it: simple, clear. School records showed 63 lost classroom hours in 9 weeks because Elena could not move between buildings without adult help. Transportation records showed $11,842.60 paid out by Marisol Ruiz for medical van service, rush rentals, and private aid time. Photos from the apartment showed scraped paint around the bathroom door where the loaner chair kept catching the frame. While that evidence came in, Martin Voss rolled his pen back and forth across the yellow pad without writing a word. I noticed the moment he stopped. It was when Dr. Raman said, "Delay in mobility for a child is not neutral. It changes the child." At that sentence, he put the pen down flat and folded his hands over it. I want to stop here for a moment, because what I am about to tell you is the part of this case that I had to sit with the longest before I felt ready to speak about it in public. Subscribe before we go further, then take a breath, because this next part matters. The second wave of evidence complicated the baseline, at least at first. Alan Mercer argued that the file had been incomplete when Lattice Care first reviewed it. He said home dimensions were missing, that the requested model exceeded standard coverage, and that the plan had offered a manual option while more information was gathered. He said Martin Voss was an administrator, not the treating physician, and relied on licensed reviewers. Those points were not empty. I weighed them. Dr. Owen Keller, whose electronic signature appeared on the denial, testified for the defense. He said he was an outside physician reviewer contracted by LatticeCare. He said he saw a summary, compared it to policy criteria, and agreed the request could wait while more information came in. He was calm. He did not present as cruel. That mattered. Easy cases are rare. On cross-examination, Cynthia Bell placed 3 screens side by side. On one was the denial letter, on one was the system log, on one was the case queue. She moved slowly. She asked Dr. Keller to read the time he opened Elena Ruiz's file. He said 9:11:43. She asked when he closed it. He said 9:11:54, 11 seconds. Then she asked him to read the time the denial document had first been generated. He said 9:10:58. That was the small piece I told you about, 11 seconds, 45 seconds after the denial already existed. I remember that line because no one in the room moved when it landed. Not Marisol, not Elena, not Martin Voss. The court reporter's keys were the only sound for a moment. The third wave came on the morning of day 3, and it changed the case completely. The witness was Nia Patel, a former senior claims analyst at LatticeCare. She came in under subpoena with a black folder and a tremor in her hand she only partly hid by holding a pen. She was not polished. She was exact, which was better. Nia Patel testified that pediatric mobility requests above a certain dollar amount were routed to what staff called a quarter-end save list. That was the phrase. She said claims staff were trained to draft denial language before physician review when a request crossed certain cost markers, then add a doctor sign-off later if the denial held. When Cynthia Bell asked whether that happened in Elena Ruiz's case, Nia looked at the screen, then at me, and said, "The denial was built first because delay was part of the strategy." I asked her to repeat it. She did, word for word. The room changed in a very small way after that. Diane Cho, one of the defense lawyers, stopped taking notes and looked down at the table. That is what I remember. Not raised voices, not any sudden noise, just one lawyer going still because she knew the record had shifted. Then came the internal messages. One from Martin Voss on June 12th at 8:17 a.m. said, "Delay is cheaper than denial because delay sounds procedural." Another said, "Hold the line on pediatric mobility until after quarter close unless legal risk is obvious." He did not need to name Elena Ruiz. Her case number was already in the chain. There was also a spreadsheet. Elena Ruiz's case number sat under a column marked deferred. Next to it was a projected savings figure of $18,640,000. Across the bottom I could see the total change when one more child's chair was pushed out of the quarter. People think screens make things less real. Sometimes they make them colder. I have been doing this for 19 years. I have heard a great many cases. The ones I choose to talk about publicly are the ones I believe need more people to know about. Subscribe and tell me in the comments what is hitting you hardest so far. I read what people write. It matters to me. Martin Voss took the stand on the 4th day. I listened to him the same way I listened to everyone else. He said LatticeCare had a duty to balance patient need against plan resources. He said he did not make clinical decisions and did not intend harm. He said the Cadillac remark was careless office talk, not policy. He said any delay came from missing information and normal quarter-end pressure. I gave those claims the weight they deserved. Some of what he said was partly true in the way many incomplete things are partly true. Health plans do make hard coverage decisions. Not every request must be approved. Administrators do rely on doctors. But here the record showed he did more than manage a process. He shaped it. He pushed it. He approved a system where denial language could exist before review and where delay itself was counted as savings. There was one sentence from his testimony that I wrote down as he said it. He said, "I did not think a delay of a few weeks would change the outcome." He said it quietly. I wrote it down because it was still wrong in the deepest way. Later, he tried another path. He said, "I have children too, and I never wanted Elena Ruiz to suffer, but we cannot let feelings rewrite policy." He said that as if policy had arrived already clean, already fair, untouched by the people who built it. I wrote that down too. The defense also made a point that deserved an answer. They said no one could prove Martin Voss personally knew Elena would miss school, develop sores, or lose the trial chair slot. That is true in a narrow way. He was not in her apartment. He was not at her school. But the law does not require a man to watch each result of what he set in motion before responsibility attaches. It asks whether the harm was a natural result of the conduct. Here it was. There is a memory from my own life that returned while I heard this case. I was 14, standing in a medical supply store with my mother after my father's stroke. The floor smelled like rubber and wax. A clerk was measuring chair widths with a metal tape while my father sat silent under bright lights, tired in a way I had never seen before. My mother kept asking which chair would fit through our bathroom door, and the clerk kept answering with prices before he answered with measurements. I do not decide cases from memory. Judges cannot do that and remain fit for the work, but memory still arrives. I remembered my father looking down at his own hands while strangers discussed what kind of movement he could afford. Then I went back to the file in front of me where Elena Ruiz had become a savings figure on a spreadsheet. I had made my decision before closing arguments ended, if I am honest. That happens sometimes. Not because I stop listening, but because a record settles. Still, speaking a decision is different from knowing it. On verdict day, the courtroom was full. Elena wore the same yellow star clip she wore the first day. When I took the bench, Martin Voss stood before I asked him to. Then he sat and folded his hands on the table. Marisol Ruiz kept one hand on Elena's shoulder. Cynthia Bell did not open her file. She only placed both palms on counsel table and waited. The air vent above the clerk rattled twice, then went quiet. I said the findings one count at a time. Guilty of insurance fraud, guilty of falsifying medical review records, guilty of contempt for violating the temporary access order through delay and misrepresentation after the order had been entered. I said the state had proved a deliberate scheme, not a paperwork error. I said the physician review had been used as cover after the fact. Then I stopped. The first reaction I noticed was not from Martin Voss. It was from Elena Ruiz. She turned toward her mother and whispered something I could not hear from the bench. Marisol nodded once and pressed her forehead against Elena's hair for a second before sitting straight again. The verdict was not the hardest part of this case for me. The sentencing was, because sentencing is where I had to decide not just what was legal, but what was right. Subscribe so you do not miss what I decided. I am getting to it now. We recessed for 2 weeks for sentencing briefs, victim impact statements, and a probation report. I read all of it. I read letters from former co-workers saying Martin Voss had mentored junior staff and donated to school drives. I read a rehab report on Elena's worsening shoulder pain. I read Marisol's statement twice. She had written it by hand first, then typed it. On sentencing day, Martin Voss looked thinner. He had no sparkling water on the table that morning, only a paper cup he never touched. Elena sat taller than I had seen her before. She had already testified by then. She had already said the sentence from her testimony I still carry. I did not want a race car. I wanted to open the bathroom door by myself. When it was time for me to speak, I did not raise my voice. I said, I am sentencing you to 90 days in the county jail and 5 years of formal probation. I am doing that because this was not one careless sentence in one meeting. This was a plan. It used delay as pressure and paperwork as cover. Then I said, I am ordering you to pay a fine of $750,000 to the Children's Mobility Access Fund at Harbor Pediatric Rehabilitation Center. I am doing that because money was the language used here. Money is one of the languages this sentence must use back. Then I said, I am suspending your authority to work in utilization review, claims oversight, or medical necessity supervision in this state for 10 years. During that time, you may not sign, approve, supervise, or influence any coverage denial. I am doing that because the privilege you held was used in a way that made vulnerable people less safe. Then I said, I am ordering 1,200 hours of community service over the next 3 years at Harbor Pediatric Rehabilitation Center and Wheels Forward Mobility Bank. This is hands-on service only. No office role, no board seat, no speeches. I am doing that because you spent too long seeing equipment as units and families as files. Then I said, I am ordering that within 30 days you appear at a public meeting of the Lattice Care Board and read a written statement of no fewer than 1,200 words. That statement will identify Elena Ruiz by name, admit that medically necessary mobility equipment was delayed under your watch, and explain what that delay cost her. It will be filed with this court, posted on the company website for 90 days, and sent to the Orange County Register. I am doing that because secrecy helped this happen. And then I said, there is one more thing. Within 72 hours, you and Lattice Care are jointly ordered to fund and deliver Elena Ruiz's prescribed pediatric power wheelchair, pressure relief cushion, tilt system, custom joystick mount, school desk modification, bathroom doorway widening, portable ramp, accessible van lift, 5 years of maintenance, and reimbursement in the amount of $38,417.22 for out-of-pocket costs already paid. I am doing that because the child at the center of this case needed movement, not sympathy. After that, I spoke to him directly. I said, what you called cost control cost Elena Ruiz, 97 days of independent movement, 2 pressure sores, 63 lost classroom hours, and wages her mother could not afford to lose. Your family did not make these choices, but they will live beside the memory of them. When a person with your title signs off on delay, that is not clerical work. That is power with duty attached. I believe you knew what you were doing. There are other cases I want to talk about. This is not the only one that stayed with me. Subscribe and you will hear them when I am ready to tell them. When the hearing ended, people did not rush out. That is one of the things I remember most. Courtrooms usually empty in layers. This one held for a moment. Martin Voss stood still while the bailiff moved toward him. Alan Mercer leaned in and said something low by his shoulder. I could not hear that. I did hear Elena Ruiz say, "Does this mean I can get to class without waiting now?" She said it to her mother, and Marisol put both hands over her mouth before she answered. I stayed on the bench while the room cleared. Cynthia Bell crouched beside Elena so they were eye level. Diane Cho stacked defense binders into a box and kept her eyes on the table. A reporter in the back row closed a laptop without typing again. When I finally stood, the room felt used up. The appeal was filed on October 21st, 2024. It was heard by the California Court of Appeal, 4th Appellate District, Division 3. On September 3rd, 2025, that court affirmed the convictions and upheld the sentence in all material respects. The panel said the record showed a deliberate administrative practice that placed fiscal timing over verified medical necessity for a known vulnerable child. It took a little over 10 months. I was not surprised, but I was relieved. What I learned later came in pieces. The first piece that stayed with me came on November 7, 2024, when the vendor filed proof of delivery. Elena Ruiz's chair was blue, deep night sky blue. The side guards had small silver stars on them because that was what she chose. The second piece came on February 7, 2026, at a compliance review I still handled. Elena rolled into my courtroom in that blue chair under her own control. No one pushed her through the doorway. She lined herself up beside counsel table, corrected once with the joystick, and smiled when she got the turn right. Martin Voss was there too. He arrived early with a maintenance log and a binder of service hours. He waited until Marisol finished speaking, then said, "The batteries were replaced Tuesday and the armrest pad was adjusted last week." That was all he said. I do not know if that is enough. I only know what I saw. I saw a man who once spoke in quarterly saves, standing in court and giving an update about a child's chair without looking away from her mother. I saw a girl who once had to wait for other people to move her back herself away from a table leg and head for the hallway on her own. The question this case left me with is this: at what point does distance become permission? How many screens, titles, policy phrases, and layers of review does it take before a person starts believing the harm is no longer his to count? I still do not have a full answer. What I do know is narrower. Systems do not turn cruel all at once. They do it in inches. A phrase here, a metric there, a delay that sounds small if you say it from far enough away. Then one day, a child is waiting at a bathroom door she cannot open alone, and somewhere else that wait is recorded as savings. If you are someone who has sat in a clinic room or at a kitchen table and felt yourself getting smaller while strangers discussed whether your need was real enough, I want to speak to that feeling plainly. I saw it in Elena's face once, right before a recess, when she looked at the floor instead of the witness. It was not fear exactly, it was the tiredness of having to prove the same truth again to people who already had the file. I saw it, and if you are someone who sits where Martin Voss once sat, not in my courtroom but in an office where your signature or delay changes the shape of another person's day, there is one question I wanted to ask him and could not ask from the bench. What would your policy sound like if the file on your screen carried your child's name? Start there. Then do one plain thing. Pull one denial from this week, follow it to the person at the center of it, and learn what your decision costs after the email is sent. I keep coming back to that gray joystick cap, small enough to lose in a coat pocket, worn smooth where Elena's thumb rested during 23 trial minutes of freedom. It was entered as Exhibit 14. It should have been just one more object in a long record. It was not. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I'm asking. Subscribe and stay. The comments are where people who care about the same things find each other.